Hey, we're live. Hi, everybody. Thanks for joining us in this, little bit of a wild cat stream here. So, as usual, I'll count this down, and we'll get going with the episode. So, appreciate you being here. 5, 4, 3.
So, Kip, what are we going to talk about today in episode 216 of the Cyber Risk Management Podcast?
Oh, this is going to be a good one, and I know I always say that, but it's true because I spend a lot of time getting ready and talking to the guests, and I just get all wound up for it. But check it out. We're going to see how one simple word changed how breach cases get settled, and the word is reasonable. Now, we've talked about
that is not a simple word, Kip.
Not for you. And okay, not for me either. But look, this is important because the standing question always is, how much data security, system security is enough? And can we be perfect? Well, no, we can't be perfect, but we can be reasonable. And what's great is we now know that there's a method for answering that question, and it's called DoCRA. And we've talked about DoCRA before on this podcast, but DoCRA is an acronym-ish. It stands for Duty of Care Risk Analysis. And now, the reason why it matters is because a lot of leaders, a lot of people listen to this podcast, and their bosses think that a breach leaves them really with two bad choices. You either pay the fine, if you're regulated, or you fight the regulator and possibly lose, right? Well, DoCRA is great because it opens up a third path, and it got written into law because it helped everyone at the table. This is not about giving one side a sledgehammer to pummel the other side with, right? Now, today we're going to talk with Chris Cronin. He is our guest. He helped build DoCRA. He's a returning guest, as I mentioned. The first time he came was in 2020. Holy moly. It just doesn't sound like a long time ago, but that was episode 59. And I know whenever we're in the sub 100 episodes, it was a while ago. Okay?
That was a while ago.
And it was a young idea back then. And the big question was whether it could even tell you your controls were reasonable. Okay, here we are 6 years later, and guess what? The answer's in. It has been incorporated as standards, it's law, and so we thought we should have Chris back to give us an update and tell us where we are, where DoCRA landed.
Yeah, Chris, welcome back to the podcast. Even though it has been 6 years or so since you've been on the podcast, it has definitely not been 6 years since we have talked or seen each other in person even. So Thanks for coming back. And then for anyone who missed episode 59, which, gosh, that does feel like a long time ago, tell us a bit about yourself and how you ended up turning reasonable into something a court uses in the context of cybersecurity and breaches.
Yeah. And before I do, I'm just going to mention, I don't know if people remember, but the way you got podcast back in 2020 is you went to Blockbuster Video and you had to rent the podcast.
Oh my God.
That's pretty, Chris. Unfortunately, there is a substantial portion of our listenership who may not even know what a Blockbuster Video is.
Back in the days of old, when you went to get your snow caps and jujubes, you would go to a place called.
They don't even know what that is. Oh my God.
I do like jujubes.
I feel like I should, have one of those old-timey phones, right? Hold the thing to my ear and talk into the.
That's right. It goes back that far back.
Yeah.
Before there was cybersecurity, we were talking about reasonability and So I'm a partner at HALOCK Security Labs. So we're a boutique firm out of Chicago, and we're hyper focused on helping organizations manage cybersecurity the way they manage every other part of their business. Right, which seems like a far cry from where a lot of people are now. They still think about cybersecurity as this wizardry that doesn't, business rules don't apply. And
this is why we like you, Chris, because Kip and I have been saying for at least 7 years, cybersecurity is a business risk.
Well, I'm an audience member too. I'm a subscriber. Yeah. I listen to you every time you've got a new episode. I'm out jogging and I'm listening to the wisdom. But
thanks for jogging for me.
Yeah, that's right.
Yes, can you jog
Yeah.
for me as well? That'd be helpful.
Yeah. Okay. This is going to be a long run, guys. You bet you.
This will
You
be a
need
long
longer
episode.
episodes.
Yeah. Maybe the trick then is to have people back more often so we don't use so much time on banter.
Yeah. That well, right. So yeah. Well, then I'll get back to business. So but that's the real issue. People don't know how, right? And this has been a real core part of what you've been doing, not just on the podcast, but in your professional lives. And what we do at HALOCK is we try to make it as practical as possible, just like the materials that you present. But what we were doing originally, this is like 15 years ago, we would say, okay, our clients need risk assessments. That's just the requirement of the regulation. They have to achieve reasonability. So let's look up reasonability and see what that means. So we can,
Yeah. How'd that go for you, Chris?
Yeah, not great. But we weren't going to rest on that and say, well, nobody knows, so good luck. We'll give you an audit, hand you your sheet of paper, and go. We said, let's try to figure this out. And I won't go into great depth. Episode 59 goes into some depth, but I'll just say how this stuff matches. Is that in law, you've got the learned hand test, which says the burden of a safeguard should not be greater than the probability times the liability of the risk. Right? So the cure can't be worse than the disease. Got it. In cybersecurity, we said risk equals impact times likelihood. So we said, if we're going to do anything for our clients, let's have the risk assessment say that the burden of your safeguards can't be greater than the risk. It's that simple. But let's say it in plain language so that our technical team members of our clients can communicate to their executives. So we're going to use a little bit of ordinal math, but then we're going to present it in plain language to executives so they can say, hey, it's more likely than not that this thing will cause an unacceptable impact to our clients, and not all of them will survive it. So that's a big risk. What are we going to do about it, right? That's how DoCRA started.
And DoCRA doesn't require, just to be clear for people, DoCRA doesn't require quantitative risk analysis, right? I mean, the formulas that you mentioned, they can sound like don't I have to plug in those numbers? Where do I get those numbers? And there's all kinds of issues with getting quantitative risk analysis in cybersecurity. It's maybe actually potentially getting easier now than it certainly more than it was 6 years ago, just with all the insurance claims, and there is more data, but it's still really hard. But there's nothing about DoCRA that requires that, right? I mean, at all.
No, you can. You don't have to. If you look in DoCRA, there's no reference to a qualitative or quantitative necessity. It says you can and should do both, and we've done both for our clients. But what we found is when we would work with our clients on this stuff, they would say, okay, yeah, this starts to make sense and it starts to be good. And then some of our clients would get in trouble with regulators, and regulators would come by and, hey, we understand there was a breach. And they would look at our clients' risk registers and they would say, well, I got nothing. I'm going to leave because you've got a definition for reasonable. And as we said a few moments ago, the regulators didn't. So if they didn't have a definition for reasonable, but a breach company did, guess who won that debate? So we were working really close. Yeah, right. So we were working really closely with a few clients over a long period of time, right? And we had this. I want to bring some of this together because there's some really important lessons to learn. And what I want from this isn't just to tout DoCRA, but I want to talk to your audience to say, you've got really great ideas about how to improve things. And if you go about it adversarially, like we were saying, kept trying to bonk someone on the head with it, it's not going to work. What helps is when you help people see the value in what you're doing in a way that helps them make their jobs easier. Like, oh, I get it. And it makes anyone else's job easier who's engaged. So we're working with Hogan Lovells, this law firm that, top tier firm. And we're working with this guy, Paul Otto, who is not yet a partner. And I said to Paul, I want to make this an open standard. I want the whole world to work with this, but it's got to have validity. People have to be able to say, I'll stand by it. Would you come with me to Center for Internet Security, who can use a risk assessment method? I want to volunteer to write that risk assessment using this thing that seems to be doing well when regulators look at it. It's already serving the client need. But I want CIS to hear how you're using it in your practice. So they say, there's validity here. So the lawyer says, this helps me with my job. I want CIS to say, this helps us with our community. So that's how our solution for our clients became, we became aware of its value. And then we made this connection between the legal and the cybersecurity community to start to make links.
And I dig that.
And that's SysRAM, just to be clear. So I'm not sure we've actually said that out loud.
Yeah. Thank you. Yeah, and CISRAM, there are two different documents here that I'll make reference to. One is the duty of care risk analysis. This is the principles and practices. When you're doing any kind of risk assessment at all, qualitative, quantitative, threat-based, control-based, whatever, you're going to look at a set of principles and you're going to apply them to your risk analysis. We'll talk about what those are in a bit. But we had to show people how to use it. So we worked with Center for Internet Security to create the CISRAM that was meant to allow the most people to be able to use it as practically as they can. So that's what CISRAM is, the instructions for applying DoCRA.
Got it. So now, not to rehash episode 59 or perhaps the many other times I have gone all law professor on this podcast, but the word reasonable does indeed have a long history in law. I mean, the reasonable man or person is the most classic formulation of it. You know, when a lawyer hears it, they think, I mean, duty of care, hence duty of care risk analysis. But it is, you know, the reason that the law uses reasonable is that whether something meets a given duty of care depends on facts and concepts specific to any given profession, right? The duty of care for a brain surgeon is different than the duty of care for a
rocket scientist.
A rocket scientist, or I was gonna say a dermatologist, or all these different things, right? Everybody's got their own duty of care, and I think one of the things that you really hit on with DoCRA is what it's a bridge, right? It's a bridge between the legal concept of reasonable and how you do a duty of care analysis and the cybersecurity field. And that's what was just totally missing, right? Because laws, you know, state, you know, for example, the CCPA has, you know, its private cause of action arises only in the case of a data breach, unless the breached entity has taken reasonable measures to protect information. So clearly, like it's I mean, the reasonable is built in all over the place. So why don't you tell us what you think about you know, how duty of care, the legal duty of care idea and DoCRA, you know, work together, and then we'll keep going with some to try to see where things have gone, right? But I think it is worthwhile to kind of finish our review of what DoCRA is.
Yeah. So I got to be sure and I don't go down a rabbit hole, because the stories there's so many fun stories about discovery here. But I'll just say that the concept that we owe a duty of care, like you could do anything you want in life, live free. Just be aware that sometimes when you're doing what you're doing could create a harm to someone. And the only limit that our government, typical Western governments, want to create is just say, whatever you do, just don't hurt someone else, right? But what they're also saying is, we're not going to tell you what specifically you have to do to not hurt someone else. We're not going to tell you that you have to 100% make sure that no one ever gets hurt to any degree. So that's how they settle on the word reasonable. Just be reasonable. And the French have said it, and the English have said it, and the Americans have said it. But the challenge has always been, how do I apply the right level of caution so that I don't hurt other people, right? Now, here's been the challenge. If you look at most risk assessments in cybersecurity, if it's a risk assessment at all, you see maturity assessments all over the place. That's what are those? But the maturity, the risk assessment is always looking at the risk to the company. What is the risk to me? What is the risk to my financials? What is the risk to my profit, right?
Yep.
Fine, you should ask that. But if you're not saying, what is the risk I'm causing to the people who might get hurt? This is when you start to tick off a lawyer. This is when a regulator says, my constituency was not in your protection program. They needed to be a central focus of what you were doing because you hurt them.
It was just treated like an externality.
Right. Yeah. People say externalities, or they use vague terms. I want to see your internal and external risks. And people say, oh, internal risk is my staff making a mistake, and external risk is a hacker attacking me. It's like, I kind of meant people getting hurt inside and people getting hurt outside. That's why regulators are there. No regulator ever went after you because you hurt yourself and only you. No
regulator or plaintiff goes after you if you screw up, but no one gets hurt. It's kind of like,
right.
No harm, no foul is the phrase there. It's not always true, of course. There's strict liability, but let's not go down that rabbit hole.
But there's a really important lesson to be learned here, and this is what was fascinating. Before we were telling people it solved a legal problem, it was solving their internal problem of technologists and executives communicating clearly with each other. So what we found was there was this internal good. It helped them find the right path. And no client ever said, it's not my responsibility to take care of my customer's risk. Every executive said, that's exactly how I want to do it. Some of our clients took DoCRA and said, we want to apply this to other parts of our business. Because DoCRA is not a cybersecurity risk tool. It's a reasonable risk tool.
It's a concept.
Yeah, right. You can apply it to any context. But if you want a sense of optimism about people wanting to do the right thing, just thinking about, we've done this with hundreds of companies. CIS reports more than 170,000 downloads of their CIS RAM material. People want to look out for their customers. They want to look out for the public. They just want the instructions for doing it.
Yeah. So, okay, way back in the mists of time in episode 59, when we talked about DoCRA, it was really just kind of starting out, right? It was a strong idea. It had early traction. I actually don't remember if CIS RAM even existed at that point. I'm not sure that it did. Did it?
Yeah.
Was it already done by 2020? Okay, so in any event, it definitely didn't exist when I first met you. That's what I'm thinking of. Because I know you were working on it, and then eventually it came out. But anyway, DoCRA has since ended up in standards and in settlements. Chris, how did this get adopted? What happened? What's been going on?
Yeah, so we talked to a lot of people, right? So it came out. It's interesting that the month that it came out, this will definitely jog your memory. There was a long battle between a company called LabMD and the Federal Trade Commission, right? And in May of 2018, CIS RAM was released, and DoCRA was released as a separate document at the same time, simultaneously. May of 2018 is also when the U.S. Court of Appeals for the 11th District decided in favor of LabMD, saying, hey, Federal Trade Commission. Yeah, what's that?
Circuit, not district.
Oh, circuit. Oh, thank you. Did I say district? Okay, circuit. Thanks. At the same time that the 11th district said, "Hey, LabMD, you are right to complain. The Federal Trade Commission should not be using the word reasonable this vaguely. It's an unclear standard. It's vague. You can't manage to it. It's not right.
Vague and ambiguous.
Yeah, vague and ambiguous. Thank you. Vague and ambiguous." The same month CIS RAM came out. So I'm now on the sort of the book tour, right? Really, hey everyone, CIS RAM, this is how it works. And I'm on a panel with a group of people who I just even still work with today. One of them was an attorney for the Office of Attorney General of Pennsylvania, Tim Murphy. And Tim Murphy was really interested in pursuing breach cases in Pennsylvania. So he's getting to know DoCRA and CIS RAM during this panel. And as we're talking, I see like these gears are moving. So he talks to me after this panel and said, "Do you do expert work?" I said, "I do now." We'd actually been doing some expert, but he brought me and my team in on cases, and before long we were working on settlements and creating injunctive terms for settlements. And he must have pushed through, I don't know, 11 settlements, but with multiple states. So he was getting other states' attorneys general involved, saying, hey, everybody, we've got this thing. Now, here's what was going on. He was able to clear cases really fast because when he was presenting DoCRA as a requirement for risk analysis on during his settlements, he would be going to the defendant's counsel and saying, we're telling you to do risk assessments. They're already supposed to do them, so okay. But you're going to be looking out for the risk to your business and to your customer. You're going to be aiming for a risk. Your plan is going to aim for a risk that would require no repair to yourself or the customer. And it's sort of a reward for this counsel. And you're not supposed to spend more on your cybersecurity controls than the risk you reduce. What these regulators were doing, these state attorneys general, is saying to the defendants, we're offering a cap on what you need to spend for cybersecurity. Holy cow, right? To the ears of the defense attorney, they're going to go back to their client and say, guess what I did? I was able to negotiate a cap to what you have to spend on cybersecurity. Aren't you glad you hired me? But what the regulators were doing, what the state AGs were doing, is they were saying, we're able to clear cases very quickly now. And
Which
we're able to look
good.
at the interest. Was that?
Which made them look good.
It does.
Yeah, absolutely. And they were also clearing settlements, not the financial portion of the settlements very quickly. They were able to move a lot of cases through. They were able to indicate that they were protecting the interests of the consumers. But then think about the AG, the actual AG who they're working for is typically I think maybe in all states is an elected position. They're able to say, we were looking out for businesses. We were not hurting businesses so much that they were debilitated. We helped them get a cap. So now the attorney general, their staff who have to do the work, the defendant, the defense attorney, the public, all benefit from this settlement because they're all represented in the equation.
Yeah, Chris, I think that's one of the secrets to the success that you're enjoying here, because so many of these risk assessment approaches, they're all about the math, or they're all about using a tool or something like that, and I don't see much or any focus on the people dimension of how these tools get used, or who's served by them or who's not served, whatever. And so I really want to applaud and recognize the fact that I think is a really important ingredient for success here, is you really paid attention to who's going to benefit. You made sure that to the extent that you could, that there were benefits for all involved, as you said at the top of the show. I think that's fantastic. So here's a question I want to ask you, though, which is, I remember you mentioned the Sedona conference.
Yeah.
It was like a place and a time that was really important. Would you give us a thumbnail sketch of what is the Sedona conference and how did that help?
Yeah, so the Sedona conference has the same ethics that you just gave. They're an organization. It's a think tank. While they've got a staff, they're run significantly by volunteers in the legal and cybersecurity and
I've been one.
I've
been a member.
Yeah. Yes, absolutely. And what they do is they try to reach consensus on difficult technical legal issues, or typically computer technology or information based.
Started off really focused on e-discovery. That was kind of one of the initial impetuses for it, is early e-discovery problems.
Yeah,
it's
right.
expanded. Yeah. It's expanded beyond that, but that was kind of one of the initial components.
Yeah, so international intellectual property issues, cybersecurity, privacy, AI issues. But the idea is that you have people who operate as adversaries at work, defense and plaintiffs and regulators, and you've got judges and cybersecurity experts all involved, typically in adversarial positions when a legal question comes up. But they say, we've got to find a way to fix the thing that we're trying to do. There's a systemic problem we have to fix before we can successfully advocate for our clients. let's come together as fellow professionals and move the law forward in a fair and just way. That's the motto.
Got it.
So I was in such an adversarial situation with an attorney who was at the time at Ropes and Gray. We were on a mediated settlement issue, and he had a point that he wiped the floor on with my side with, and there was one that I wiped the floor with his side with, and mine was on the question of reasonability. And we were in touch with each other after this settlement was done, and he said, "Hey, I'm part of this thing called Sedona Conference. We're in the middle of defining reasonability. We want to develop a test for reasonability, and I think you're going to be helpful. Why don't you join?" So I started working on this paper with this group of people. Guess who was on that team? It was a regulator from the Federal Trade Commission and an attorney from the Ropes and Gray team who won that battle for LabMD. In other words, the adversaries who broke the word reasonability in the 11th Circuit were now working together to fix the word reasonability. And as a latecomer, they welcomed me in and they said, let's do this with you. And what we did was we said, let's take that learned hand test and let's apply it to a cybersecurity context where you have to decide between two different controls. I've got the control I'm using now. I've got the control that someone alleges I should be using. Would we both be better off if I'd used that other control? It's this balancing test where the company and the purportedly or so said the claimant's injured parties are both considered in the evaluation. So the paper came out in 2021, and by then, AGs like Tim Murphy were able to just say, let's use this as our definition for reasonability, because it was written by a consensus of plaintiffs, defense, judges, regulators, and cybersecurity folks, and let's use CISRAM and DoCRA as the technical language we would use for applying that test in a risk management context. So that's
I
that
appreciate
story.
you describing that for us, because that's the kind of like deep thinking that is really rare, where you get the right people in the right room, focused on the right thing.
Yeah.
So I just wanted to make sure that we recognized that happened. Okay, so we wanted to ask about how much this has spread. So where is this happening? You've mentioned different places, Pennsylvania and so forth, but is it just the United States?
No, it's branched out into the EU in a very surprising way. But I'll talk a little bit about how it's in the U.S. states. In some cases, you have attorneys general who are using this in their settlements to explain this is what we're expecting of you. And if you've read settlements, you should also realize those are communications to the public saying, by the way, these questions are going to come up, and this is how we're going to determine things like reasonability. So why doesn't everyone read this? They're meant to be public announcements, basically. So I don't know, there might be 15 or 20 states who have all joined in some kind of multi-district litigation that use DoCRA and CISRAM and the Sedona Conference paper as guidance for definitions for what reasonable is. Then there were other states, just every other state except for California, who used their own way of describing the balancing test to determine acceptability of cybersecurity risks. There's a big decision of all these states against Marriott, where they said, this is how we know that a risk is. They use the word acceptable because reasonable was a hot potato for them, but it's still a statement to the community. Understand, when we, as a set of states are going to come after you, we're going to say reasonable, and we're going to say acceptable, and we're going to use this balancing test. In Colorado, their privacy regulation has a section called duty of care. And under that headline, they describe reasonability. Here's how you determine whether you're being reasonable. And they use their DoCRA formulation in there. By the way, and this is important for your listeners to know too, the reason why that's in there is because the Colorado Attorney General's office is very responsive to public input, and went through public review to say, everyone, we've got this statute that tells us to create this regulation. Here's a draft. Everyone, time for public comment. Anyone who has any express idea of how to make this better, write in. And a team of people wrote in to say, can you use this DoCRA formulation? And they adopted it. So people should know this about how regulations are made commonly in the United States at the state and federal level. Not every state does this for every regulation, but watch for regulations that you care about and contribute. Colorado is now doing this for their AI regulation. California, this is the last time I'll go into depth about a state, because this is extremely interesting. California updated CCPA. There's Article 9 that says, hey, everybody, you have to do an audit to be sure your security controls are in place. And by the way, California uses a reasonability standard, as Jake said.
They do.
Article 10 says you're going to do a privacy risk assessment. And the privacy risk assessment is going to verify that you're not putting consumers at a greater risk than the benefit they get, or the benefit the company gets, or the public gets. So now they didn't say follow DoCRA, but they said exactly what DoCRA is here to say. You are not allowed to put consumers at a greater risk than the benefit you're providing them, or the benefit that anyone else is enjoying. And hallelujah, right? Because now the conscience is taking, and I didn't have anything to do with that statute or the regulation that came about. This is them saying, we've been looking at what's going on in other states, and let's make this explicit. You're not allowed to put consumers at a greater risk than the benefit you provide them. Think about how powerful a statement that is. Look at the headlines about abuses in social media and AI and saying not allowed anymore.
I really like this, Chris, because one of the biggest barriers that I was aware of when somebody had their data caught up in a data breach was they couldn't prove harm. And so they had no standing.
Right. Right. And that continues to be hotly debated in these matters. And what's been really helpful, if you look at, so if you go to CISRAM, it's freely available at the Center for Net and Security's website, and you download it, you will see for implementation groups 2 and 3, you're going to see clear instructions for how to state the harm that you're trying to avoid in plain language. From the public's perspective, or your company's perspective. But you can say things like, if there was information that leaked that you don't want it to leak, but you can't foresee how anyone could abuse this information to create any kind of harm, like exploitation or embarrassment or financial compromise or these things. If you can't think of how that breach would have caused a problem, then that would be, an acceptable level of risk, and there's a way to score that. But if you get to a point where a breach could create a foreseeable harm that could be fully repaired, but it would be a foreseeable harm that you would have to fix, you've crossed that line. Now you're into unacceptable risk. And it aligns with the concept of standing. Is there a harm that you suffered that could have been avoided, that requires repair, that's a result of this behavior or the system? That's a test for standing. So what's happening is the cybersecurity person is just trying to figure out a way to communicate to her boss. So she says, well, let me fill in what acceptable looks like. Let me fill in what unacceptable looks like in terms of someone's harm. And before you know it, everyone's behaving.
Yeah, that's great. That's great.
Yeah.
Now, time being what it is, we are going to need to move on. And I'm excited about this because there's a real case, right? There's a real case that we can look at. Let's do that, please. I want to know.
Yeah, and again, this is something that I really love because I wasn't in the room. No one ever needed to advise me. But this was a multi-district litigation. Okay. I know it. I think 4 states were involved, but Pennsylvania again was leading it. So it's Tim's on the charge, but he's getting every other state revved up. This is a software company that provides an electronic health record application for pediatric physicians' practices. So your child's doctor, right? They're relying on the software. The software has a breach. And if you read the complaint and you read the settlement, you realize there were some real issues at this company. The thing is that if now these states, when they have a lawsuit, they look to past settlements and they say, hey, look, in similar cases, the settlement was X millions of dollars. And they realized that if they applied that typical penalty to this company, it would go out of business. Now think about, again, what the Attorney General is saying. I can't be wiping out businesses.
Well, that's a corporate death sentence.
Yeah, right. Exactly.
Sometimes depends on who it is, but generally not.
Right. But for this company, it would have crippled them. So, and now at the same time, I'm at a conference, a very tight conference of organizations that get hit real bad, and their attorneys on both sides and regulators. And it's like Sedona conference, but we don't issue papers. We just sort of work things out, right? And this Fortune 500 CISO comes up to me and says, please, Chris, do us all a favor. Could you go to your regulator friends and tell them that our cybersecurity budgets are depleted because their fines are so big? How can we fix the problems if we spent tens of millions of dollars on the fines and fees and settlements? I said, that's an interesting point. Let me bring it up. So I went to these AGs, and they were working on this case. I did not know about it. But they said, hey, we got a case we can apply that to. And it was this Connexin case. And if you read the case, you see that they're saying, apply DoCRA, do your risk assessments, CISRAM's a good guide, follow the math in the Sedona conference paper, and manage these risks. And we will not, we're issuing the penalty, but we won't collect on it if we come back and see that you're actually managing your program the right way. We'd rather you use this money to run a cybersecurity program so your business operates in a way that's safe for your customers and their patients. Because the people who are actually potentially harmed were children.
Right.
Yeah. But they said, it's important you get this right. We're going to come back and check.
Yeah.
So this is one of these moments where regulators just said, everybody, let's round up and make sure that everyone's okay and everyone's taken care of.
And that goes back to something that I praised you for earlier in the episode with this approach where, all stakeholders are being considered, and all stakeholders are getting something that is helpful, that they see as a good, and there's no there's no stakeholder here that's being treated in a punitive way, simply to be punitive. Nobody's being categorized as, well, you have no standing, so get out of the room. This isn't about you or whatever. And this is people, right? You're addressing the people issue, and this is the part that's just missing so often.
It is
in cybersecurity conversations. So I can't help but to be excited to see that it's happening here, Chris. Thank you.
Yeah, it's a real pleasure, and I'll say that it's a great way to make a living when you tell people that they can aspire to do well, and they say, "Oh, can you show me how?" And they just want to know how to do the right thing. We were making jokes earlier about recognizing pop songs from the '80s, but we also know Milton Friedman's mantra that at the time that the only social good that a company owes is profits to its shareholders. This Friedman doctrine that people were talking about as we were growing up, and people were behaving that way. Now, when you're watching movies like Erin Brockovich or Dark Waters, and you see corporate malfeasance, and you see the lone attorney or the lone community organizer finding that document and bringing that document that says, yeah, we're taking care of our profits and not the people, and the audience go, they got him, they nailed him, they got the memo. That memo is your risk assessment. If you said, I'm looking out for my profit, and you're not saying, I owe it to my customers and the public and the children who are patients of the doctors, I owe it to them to make sure they're okay. But they owe it to me to make sure that I don't go broke in the process. So we're going to do balancing.
And even though Delaware corporate law still only recognizes really the duty to shareholders, it's not actually in conflict, right? Because if as leadership I engage in unreasonable risks and I cause damage to other people, Guess where that money comes from? The profits. So you actually, by complying, or not complying is the wrong word, by acting accordingly to protect yourself and others, you actually are ultimately protecting the bottom line. That's why it all works, right? I mean, it does all kind of come together in that sense. And I think, one of the things that I think, I'm curious what you think, Chris, but it would strike me that in a lot of situations, the actors that get in the most trouble are the ones that just never do a risk analysis of any kind. They just because and we've all talked about this before, but you've got this wonderful business judgment rule that protects the corporate decision makers from various forms of liability. We won't go into details on that, but essentially, like, not making a decision is oftentimes way worse than making a call. If you're wrong, you can be wrong, right? But the question is, did you actually make the decision, or were you negligent, right? One of the things we haven't talked about with the whole duty of care and reasonable thing is that comes up in tort law, and the classic negligence tort is where there is a duty and you unreasonably breach it. That is effectively the basis of tort law. We're going to ignore intentional torts where I come up and punch you. Those are a little different. But
don't worry, everybody. If you see Jake at a conference, he's not going to punch you.
No. There's a difference between intentional torts and negligence. This is first year law school flashbacks. But these concepts, like we talked about, they are there as this is the mechanism to avoid anarchy and duels at high noon. And I think sometimes people forget about, lawyers will sometimes get a bad rap, and it's like, oh, we don't need the lawyers. You really do want the lawyers, because the alternative is, sir, I challenge thee to a duel, and or meet me at the center of town at high noon for a shootout. That's how disputes were resolved.
Yeah, I like Hamilton. That was a good show.
Yeah. But not ideal for doing business. So anyway, I'll get off my little soapbox there. But I think this is all it all is wrapped into DoCRA and this concept.
Yeah, it's important from that legal perspective. So then, helped communication, right? Helped in the legal context. I was surprised when I saw that that there was a paper, a technical report out of Etsy, which is basically NIST in the EU, that said that, hey, look.
For a minute, I thought you said Etsy, like this website where you go and like buy random things.
Yeah, if you want to get a sweater with your name embroidered on the front, yeah. So ETSI.
Is that where the DoCRA swag is?
So it is Etsy, but it's a different Etsy.
It's a different Etsy. Yeah, you can't get macrame there. But ETSI, but they're basically NIST for the European Union, and they provide basically the technical standards for how you're going to follow these laws, like the harmonized standards that the EU is putting together. The EU has this completely different problem. They're saying, hey, our innovation is lagging. We prioritize protecting people because we tend to do terrible things to populations when we get their personal information. Even in our age, we saw what happened in the Balkans. We don't want people to abuse personal information because we can't trust ourselves with it. But they protected people to the degree that they were hurting business. And they say, name a single AI innovator in the EU right now.
Okay. I win. But they have fallen behind.
Right, exactly. And the EU is trying to fix this with a set of harmonized rules. So when you see the AI Act, you see CRA, you see NIS2 that require risk analysis. Etsy steps in and says, here's how to recognize risk assessments. Use DoCRA. And I saw this and I said, what? And they said, because guess what it does? It helps you balance innovation with protection of the population. that one thing solving a different problem. It wasn't a legal context problem. It was a balance problem, which is essentially the question that you're raising with the shareholders value question, Jake, in the U.S. So that just made my day, because but to the point that Kip you're making, if people don't know how to do risk assessments, it's going to be really hard to do. So we wrote up those steps in CISRM and gave it away to the public. It's not the only way to do a risk assessment.
Right.
It's just a very quick and easy way to make sure that your risk analysis takes care of your business context and equates that with the harm you're trying to reduce for others.
Yeah, what's interesting is if you go to the NIST publication on risk assessment, they have a whole page in there that lists everything I've ever thought of and more. I mean, a gap analysis can be a risk assessment, according to NIST. So, so anyway, so I just want to affirm what you said, which is, there's more than one way to do this. Now, again, time being what it is, and I know I'm the official timekeeper of this podcast.
Party pooper, you're the party pooper of this podcast.
I know. Such a good time with you guys.
I'm the wet blanket. I get it. That's cool. I can deal with it. But Chris, let's bring this home.
Yeah.
What should our listeners be doing? I'm assuming at this point they've decided DoCRA equals good, but okay, but maybe they're not in a litigation. Maybe they're not being pressed on by a regulator at this moment. So what's something they can do now?
Well, what I really recommend is that for practical purposes, just download a version of CISRM. If you're a small organization, implementation group 1, just explore it. They get more and more interesting as they go up to implementation group 3. I won't go into detail, but look at it. Look at its instructions and a workbook, and you find yourself doing a risk assessment pretty quickly. Boy, CIS really raked me over the coals to make that as simple as possible, and I love them for it. They're just mission-oriented, great people. So do that. Talk to your general counsel or outside counsel or whoever and say, hey, if I describe this to you, and just show them the CISRM document, would you be able to defend me if I got into trouble? And that general counsel is going to become your friend right away, because they live in two worlds. They have to manage innovation and liability. They have to straddle that for the company. That's a hard road. And if you show them that there's something that's practical that the cybersecurity people can do, that's being accepted in courts and by regulators, and now on 2 continents, that general counsel is going to say, yes, do it. I'll be your champion. I'll make sure that you get this done. So we made it as simple as possible to do. And that relationship with general counsel to make their job easier is a really good key for our clients to progress.
Again, I like that you're injecting the people angle here. So if I'm a chief information security officer, or if I work for one, what you're saying is go meet the general counsel, go bring DoCRA to your general counsel and talk about it that's one possible next step for you. I think it's a great idea, because you really do need to have a conversation with your general counsel before you end up in an adrenaline-soaked situation where you've never talked before, right? So, so that I love that. That's a great next step.
Yeah, and we've got a lot of material at HALOCK.com, the videos and stuff that give you other scenarios like insurance. Do you realize what this does to cyber insurance? The insurance industry shows that about 45%, if you're below $2 billion in revenue company, about 45% of your breach costs go to liability-related costs, fines, fees, settlements. So if you're able to demonstrate from the get-go, I had the incident, still have to cover the 55% of that cost, but 45% of that cost can virtually go away, because when an attorney looks at my risk register, they say, you've got a definition, I don't, and the conversation's done. So what this does to cyber insurance is just terrific. It went down. So if you go to HALOCK.com, you'll see we've got a lot of material there that shows you a lot of different ways that this will help you.
And I like this too, because we do something different, right? We have a cyber risk management action plan. We also have an AI risk management action plan, which is just a different approach. But it's still operating in this concept of reasonableness. It still generates the kind of documentation that you can show to your regulator or to your biggest customer, or that you can bring into a courtroom if you got sued, and you could say, we were being reasonable. Let me show you how we were being reasonable.
Yeah, and more than that, and this is what I found, showing people how reasonable works is one thing. It's an intellectual exercise. Making it easy to do, which is what you've done, making it easy to do is a huge challenge. You've succeeded there. And CIS really had to rake me over the coals to make CIS REM easier. We got there. Like HALOCK, we've got these loyal clients that don't let us go. We just are with them for years, just like your situation. They're with us forever. But we realized that even then it was a challenge to do. We had to build an application.
It's really
we call
hard.
it reasonable risk, because how could you not?
Yeah.
But that just does the risk management portion. So but you have to simplify, because
even more than you think.
Yeah, way more than you think, and but because we have to make it easier for people to step in. So I applaud everything that you've done.
Thanks a lot. And I think this has been a great conversation. We do need to wrap it up. And so, Jake, any last words? I cringe asking you that.
Don't ask that question. Yeah. I mean, no, I have a large number of such words, but for the moment, I'm going to say, no, Kip, we can wrap it up.
Okay, all right, that's fantastic. You rest your case. All right, good. So, Chris, it's been great to have you back, and I know you're going to do more great stuff. We'll probably see you as a guest again in a future episode. But today we talked about DoCRA again, and this is a method that turns the idea of reasonable into something that a court and a regulator can actually use in order to get real things done, to actually improve the cybersecurity of the world that we live in, which I think is great. So please go back to episode 59 if you want to, get a deep dive into DoCRA, because that's not exactly what we did today. But today we showed it as a case study of how it actually worked in the real world. And so what did we see? We saw how it's gave every party a win, and how it gave one breached company a path that wasn't the traditional pay the fine or fight and maybe lose. I think this is a great evolution of our profession and the work that we do. So thanks for coming back, Chris. We'll see you next time, everybody.
See you next time.
Take care.